All right, so we're going to get started. Thank you for joining today. This is a part one of a two-part webinar series with an introduction on private client law. My name is Casey Nielsen, and I am the head of the employment team here at Dragon Argent, and I'll be asking today's questions. I'm joined by James McMullan, who is the partner and head of private client at RIAA Barker Gillette. And he'll be helping us navigate today and answer your questions on wills, trusts, inheritance tax, and tax planning. The webinar will be recorded, and it will be available on our and on RIAA Barker Gillette's websites. So feel free to take a listen back after this webinar. And please type any questions into the chat box. We'll approach them at the end of the webinar and answer them then. So let's dive in. Hi, James. How are you doing?
I am well, thank you, Casey. Thank you for inviting me along this morning.
Thank you. So let's start. Why should business owners, or anyone for that matter, have a will?
Okay, I would say there are three main reasons for having a valid will. Firstly, a person dying without a valid will, the intestacy rules will apply. And they are automatic succession rules which are imposed by statute. They're quite rigid, and they don't really cater for today's modern family structures. In fact, what can happen is that there's a risk that the estate will pass to persons that you would not want to benefit. Secondly, the intestacy rules also do not make provision for full use of the exemptions, allowances and reliefs under the inheritance tax legislation. So, if we take, for example, the typical family, husband, wife and children, and say it's a £1.2 million estate, which is not large by today's standards, and husband dies, the surviving spouse will receive the personal chattels, personal possessions, a statutory legacy of £322,000 and one half of the residue. The other half of the residue goes to the children on statutory trusts, and that would result in a tax bill of approximately £45,000. And so finally, third reason I would say for making a valid will is that quite often you find without a valid will, there can be a probate dispute within the family. So it's an opportunity really to decide what you want to happen with your estate. So really, not having a valid will, I would say, is a disaster waiting to happen.
And so to avoid potential disasters that you've just mentioned, what estate planning do you recommend happens?
So I would say it's far better to sit down with a private client lawyer, a specialist in wills and trust drafting, who will be able to assist you in identifying your objectives and priorities, who you should benefit and to what extent, and also just, so that your loved ones will remember you as someone who did the right thing. If we go back to our example of the married couple with the £1.2 million estate, and they make simple wills gifting the entire estate to each other, remainder to the children, that will result in no tax bill on the first death, and possibly no tax bill or perhaps a very small tax bill on the second death, if all the exemptions and allowances can be claimed.
Yeah.
I would also say that, making a will is an opportunity to structure your affairs in the most tax efficient way possible on death, but also it's an opportunity for us to have a discussion with our clients and consider any possible additional lifetime estate planning steps that they might want to take and may be available to them, particularly if you have business owners or high net worth clients. We can advise them on the various allowances, exemptions and reliefs available under the inheritance tax legislation.
That's great. So after you have sat down with a client and identified their objectives for making their will, planning their estate, do you just write it down on a piece of paper? Is it a one will fits all approach, or is each will unique?
Well, there are various different types of will structures to suit different family arrangements. I would say that each will is unique to that individual. It's important, going back to the intestacy rules, to bear in mind that the intestacy rules were created and developed around the traditional family, the husband, wife, children scenario. They don't really cater for the modern family arrangements. The law moves very slowly and hasn't really caught up with these changes that we've seen to society over the past 20 to 30 years. So it's more important than ever that you've got a will in place that suits your family's needs. Going back to the various structures of family out there, you've got, if you think about it, you've got your conventional family, husband, wife, children. You have second marriages with children from the first marriage or previous relationship. You've got blended families. You've got cohabitees who are not in a marriage or civil partnership. So, all these different structures need to be catered for. We still meet clients even today, who talk about their common law husband or wife. And this is not a concept that's recognized under English law. And so, for example, if you have a couple like this and one of them dies, the surviving partner cannot benefit at all under the intestacy rules if there is no will made in that situation. I should just add that we can advise clients on Sharia compliant wills as well, which are wills which are made in line with the rules of succession under Islamic law. But just thinking about other things, other reasons why you might want to make a will, if you've got minor children or a disabled person in the home or someone who's just vulnerable, it may be worth thinking about putting a trust structure in place to provide for them, their support and assistance going forward when you're not there. And trusts can also be a very useful way to manage family wealth and provide that level of protection to a vulnerable person.
That's great, thank you. What other things are there to think about when a client of ours or any individual is thinking about making a will?
Okay, so I would list a number of things here, just taking our standard will structure and working our way down. First of all, who would you want to appoint as the executors and trustees of your will? You can appoint your spouse, children over the age of 18. You can appoint relatives, friends, or professionals, or a combination of those. The maximum you can appoint is 4 people, or you can have a trust corporation, which is a specialist company created to provide that level of service. But also think about the health and the age of your appointees. Are they going to be around when you need them? Think about, for example, their skill set. Are they good money managers? Will they be able to bring any other relevant skills to the table, legal skills perhaps, to the job? But also, I would say really important also is the personalities of your appointees. You want to avoid a clash of personality if possible, because that can cause other problems in the administration of the estate. I had a case not so long ago involving 2 brothers who were appointed as the executors of their mum's will, and they simply did not get on. So we had great difficulty in that situation. One brother was particularly hard to deal with. He would not cooperate with his brother or with my firm. We did try to resolve the matter amicably, but in the end, we had to make an application to the court for his removal as executor. The matter was eventually resolved when we got to the door of the court and he backed down. And so an order was made whereby he gave various undertakings to cooperate in the administration. But obviously that was not before a very large legal bill was incurred of some £25,000-30,000, which unfortunately went out of the available pot going to the beneficiaries. So they lost out as a result of his conduct. So yeah, really important to think about those sorts of things. Next, I would suggest appointing testamentary guardians for infant children. And obviously we're talking here about a scenario where both parents have gone, which is unlikely, but it can happen. And you want to think about, again, the personalities there, because the skills involved in raising family are different to that of an executor trustee. So you don't necessarily want to appoint the same people as guardians, also as trustees. And there is potentially a conflict of interest between those two roles. So it's best usually to separate out those particular roles. Next, I would suggest think about the structure of your will. Perhaps the most important thing is to make sure that the will meets the needs of the family. And secondary to that are tax issues, trying to make the will as tax efficient as possible. Excuse me. We would usually sit down with our clients and ask them to provide us with a schedule of their assets and liabilities so that we can see the nature and extent of the assets. And bearing in mind that certain types of assets qualify for certain specific exemptions and reliefs under the inheritance tax legislation. So thinking about your business owners, business property relief, agricultural property relief, and there may be others. Next, more complex scenarios. So for example, if you have a client who is foreign domiciled or their partner is foreign domiciled, that has tax complications which you need to work through. Perhaps they have assets abroad, and then the question arises, should you make a will in that jurisdiction to cover those assets, or will their English will cover all of their assets worldwide? Digital assets, this is the next big thing nowadays that we're dealing with. If you have digital assets, how will your executors be able to access them? And that's a tricky one. We are still struggling with that ourselves in the law. Going back to business owners, business interests, think about how the business interest can be passed on. So, firstly, the structure of the business. Are you a sole trader in a partnership or a limited company? Do you need a shareholders agreement? It will be important to look at the articles of association of the company or the partnership deed. There may be restrictions in there or conditions preventing the transfer on to the next generation. Yeah. So that needs to be considered. I suppose just thinking about succession issues generally, if the plan is to sell the business interest to the existing partners, then think about how they can fund that purchase from the deceased person's estate. For example, do they have key man insurance in place? I think lots of things there. There are a few other bits, but those I would say are the main ones.
That was very detailed. There's a lot. As we said, this webinar is recorded, so you can always listen back and also get in touch with James if you've got any questions. So what kind of will disputes do you come across, and how could these have been avoided had people put wills in place? Okay, so there are many types of will disputes, and that would be the subject of a whole other discussion. So I won't go into those. But as I said above, not having a valid will in place can result in a probate dispute, but so too can a poorly drafted will or a poorly thought through will. Really important to get good guidance and professional advice on that. Probate disputes are hugely costly, not only in terms of
being able to resolve them, the legal costs involved in resolving them, but also the huge damage caused to family relationships by such a thing. Typically, tens of thousands of pounds are spent in resolving these disputes, whereas, spending a relatively small sum of money to get good professional advice and guidance, to get a good will in place, can save a family an absolute fortune in legal fees. We can also hopefully make some tax savings for the family through that process, not to mention, of course, avoiding the stress and grief of a probate dispute and legal battle at a time of mourning.
Yeah, absolutely. Yeah. And once people have got a will in place, what then? Are there certain requirements to make a will valid and binding?
Okay, so we have two questions here. Making a valid will binding, that is more really the responsibility of the professional will drafter, making sure that the will complies with the formalities of Section 9 of the Wills Act. So clients shouldn't really worry too much about that. But going back to the previous question, what things to think about when you've got a will in place, I would suggest the following. So firstly, really important to make sure that your original will is safely stored and that you've got backup copies in another separate location. Secondly, think about perhaps registering the will with the National Wills Register held by a company called Certainty. Most law firms that specialize in this area are members of Certainty. My firm is a member of Certainty, and we provide that service to our clients free of charge. And the way it works is that we will store the will in our safe store. The will is registered on the National Wills Register. And the idea behind it is it's like an insurance policy. So if, for example, you make your will with me today, we put it away in storage, many years pass and 30, 40 years, you're very young, you pass on and your family don't know where the will is, or if you've made one, they can't remember. They can do a search of the National Wills database. That would lead them back to our firm or its successor, and the will can be produced for probate. So so that's a really good idea. Thirdly, I think it's a good idea to speak to your executors and trustees, check that they're prepared to take on that responsibility. If they are, then tell them where the will is stored and make a note of that for future reference. They don't need to have a copy of the will. Some people like to do that, but it's not necessary, as long as they know where the will is stored. And then I guess finally, we would suggest that you keep your will up to date, your will and your financial arrangements up to date. So perhaps review your will every 12 to 24 months and always on the occasion of a major life-changing event. So birth, marriage, civil partnership, divorce, separation, disability, death, or indeed receiving a windfall, an inheritance from a parent or relative. And oddly enough, these lifetime events, some joyful, some sorrowful, they can be an opportunity for further estate planning, inheritance tax mitigation.
Yeah, that's great. Thank you. We've got some questions from the audience. I think our chat is not working. If you want to ask some questions in the Q&A, then those we can read through. We've got a couple here which we'll start with, and then if you've got any others, feel free to push them through. So the first one, please can you explain the difference between an executor and trustees? Sure.
So we tend to use the terms interchangeably, but really the role of an executor is to administer an estate. So if you think about the process when someone dies, it goes through probate, you gather in the assets, you pay the debts, and you account to the beneficiaries for their inheritance under the will. That process can take anything between 6 months for a very small estate to 2, 3, 4 years sometimes. But once the estate has been administered, the role of the executor essentially comes to an end at that point. Now, if there is a will trust, so if you've got minor children, a disabled beneficiary, whatever, and you've provided for in a trust, the executors metamorphose into trustees, so they will carry on their role in managing the trust for the minor beneficiaries or whoever it may be. So yes, they have separate defined roles, but they can sort of carry on.
Yeah, and they can be the same or different people.
They can be the same or they can be different people, exactly.
Great,
yeah.
Thank you. Second question, are you doing another webinar on private client law? Yes, we are actually. Thank you for prompting that. That was going to be something I was going to raise at the end. As I said, this is part one of a two-part series. So we are doing a second one in March, 15th of March, which will cover lasting powers of attorney, medical and financial, lasting powers of attorney for business owners. So for example, who is appropriate person to appoint as an attorney? And as a business owner, if you were to suffer any injury or lose capacity, looking at potential conflicts of interest if you nominate your business partner as your lasting power of attorney. And then the third point that we'll be covering will be lasting powers of attorney for personal affairs. So that will be part two webinar on the 15th of March. So sign up as well if you'd like to attend and listen in on that. That will also be recorded as well. So don't worry if you can't make the 15th of March, you can listen back to it. The webinars will be available on both our website and on RIAA Barker Gillette's website as well. We've got another question, which is how often should you review/renew your will? I think we did briefly cover this, but you can answer it.
Yeah,
again.
so as I was saying, I would suggest certainly every 12 to 24 months, and always if there is a major life-changing event. I mean, we like to have an ongoing relationship with our clients, so we're very happy if they pick up the phone to us and say, this situation has happened, what do you think? And we can have a 5-10 minute chat. It might just be a case of giving them a bit of reassurance and telling them, yes, your will is fine, leave it as it is, carry on. Or it might be a case of saying, well, maybe you could think about this, change this, update the will in some way or other. So yeah, it's horses for courses.
Thank you. Then we have got another question. I have 2 granddaughters. I want to make sure that they have the university fees paid for when they graduate. Can I ensure that the fees are held in an account so that the money is only paid on graduation if I die before they graduate?
Okay, so I guess you're talking about creating a trust account for your grandchildren. Yes, I mean, obviously, it's a case of ensuring that you appoint the right people that you know and trust, or professionals if it's at that appropriate level where it's not going to be too costly to manage. But yes, certainly that could be created in the form of a trust and managed for the grandchildren to pay school fees or whatever the case may be.
Great, thank you. Another question, lots of questions. Are there any changes in law or inheritance tax we should be aware of?
Well, unfortunately, the reality is that there are often changes to tax law. Every time we get a budget, we have to scan the small print to find out, because it doesn't always hit the headlines. I know that the government has been talking about making changes to inheritance tax. It's a wait and see situation. You just have to keep an eye out and pick up any valid information that's out there. And again, as I said, if you're not sure, get in touch and get some good advice.
Yep. Actually, James's company does send out a lot of great newsletters on the topics as well. So if you were to sign up to their newsletters, you'd be told as and when inheritance tax comes up or any other kind of updates.
Yeah.
Another question, if you leave everything to your wife, for example, can you specify that certain elements of the resultant estate can be passed on to individuals chosen by the deceased, i.e. me? How binding can this be?
Well, so if you make an outright gift to your spouse, then you cannot dictate what happens after that, because it becomes in your spouse's estate, and it would be dictated by her will when he or she eventually dies. So if you wanted to make provision for what happens after your spouse or partner dies, you then need a trust situation. So say, for example, a life interest trust, providing for the spouse or partner to be provided for by the trust during their lifetime, and then after their life comes to an end, the life interest comes to an end, what happens then goes on to the next generation.
Okay, thank you. Where there are business and family considerations, should one just use one law firm, or would this be two different firms?
Well, I guess it depends on the law firms and whether they have the requisite expertise to deal with that.
Yeah.
Not every law firm covers all of the areas of law. Some specialize. So it really just depends on the firm you're dealing with.
But you could do that.
You can.
Okay. I guess that question stems from if it's a business owner who's doing their personal will, and then they also want to know, I think with the things you mentioned about considering a shareholders agreement and articles. So
Yes.
that's that combination.
Yeah.
Okay.
Yeah.
Can a deed of variation following intestacy create a life interest trust for property?
Yes, you can have a deed of variation to alter the terms of a will or the outcome of an intestacy, but it's not always possible to do a deed of variation. So, for example, if you have minor children, you can't. The surviving parent cannot speak for the minor children. Their interests are separate to the parent. You would have to make an application to the court, and the chances of that being granted are quite slim.
Okay.
So again, as I said, that's another very important reason why having a will is so important to cover that situation.
Does that create a lifetime trust or a will trust? I think that's a follow-on from that question.
Yeah, so if it is possible to have a deed of variation, you can create a trust through the deed of variation. So yes, it is possible if, for example, the children are adults and can speak for themselves, full age and capacity, then they could sign the deed of variation. So everybody who's affected by the deed of variation would need to sign up to it voluntarily.
Yeah. Okay, thank you. A two-part question. One, is money in a joint account considered part of my estate for inheritance tax purposes? And two, if the person, my son, moves some of the funds from the joint account to their personal account, would those funds still be considered as part of my estate?
Yes and yes. So even though the funds are in a joint account, it doesn't necessarily mean that they're held 50-50. It could depend on the intention of the parties. So for example, if you have a very elderly parent and they put their son or daughter as a joint name on the account to help them manage the account, that doesn't, the intention may have been that it's still my money, but you're helping me to manage my affairs, pay my bills. Or it could be, I'm giving you 50% of my money. The starting point is, I suppose, that money in a joint account is capable of being drawn down by either party to the account. So you do need to, I suppose, really document what the intention is behind that. But certainly, even if the funds are in a joint account, it is a requirement to declare that wealth as part of your estate on death.
Okay, that's a very good question. I've got a joint account, but note the intention. Keeping inheritance in trusts versus other types of assets. What is best and what is most tax efficient?
That's a good question. So, excuse me, we would certainly look at your asset base and discuss with you what your objectives are here. For example, if you have a particularly valuable heirloom that you want to keep in the family, then yes, maybe a trust would be the best way to do that. Generally speaking, we wouldn't put chattels, personal possessions, in trust because there are other complex considerations there. You know, how can that particular chattel be managed? Does it need to be insured? Does it need to be maintained or repaired? Where will it be held? How can the trustees ensure that it's protected for generations going forward? So it carries other considerations. Generally speaking, trusts tend to hold money, property, investments, that sort of thing. Can also be business interests. Yeah.
Thank you. Are gifts of money inheritance tax free?
Well, you're talking about the reliefs and exemptions here. So there are a number of options there. I think possibly that's the subject for another video clip. But taking some simple examples, you're allowed to give away £3,000 a year to anyone you wish. That's your annual exempt amount from inheritance tax. There are also small gifts of £250 that you can give to any number of people each year, not in combination with the £3,000 gift. Once you go above that, then you're looking at other things about potentially exempt transfers with the 7-year rule applies, surplus income. There's a number of them we would need to work through.
How can you get around people seeing wills as published at some stage, but are no ways around this?
Okay, so wills are, when a will is admitted to probate, it does become a public document. Okay. So anyone can access a copy of that will. There are certain people who will be able to restrict or prevent a will from becoming public. For example, members of the royal family, that would be appropriate. But it usually does become a public document. So yes, they need to be aware of that.
And is that only when it goes to probate? So
only when it goes to probate, not before. Because obviously you can change your will at any time. So if you make a will today, you can make a new will tomorrow, next day. It's only the last will that applies at the date of your death, the last will you make, which is the valid one that usually goes to probate.
Okay, thank you. And then, do all assets automatically pass on to your wife/husband after death if there is no will? If so, can you specify what your inheritance will be spent on, such as kids' education?
Well, the answer to that is no, they don't automatically pass. We were talking earlier about the intestacy rules, and this is a reason why you want to have a will. You want to give deliberate thought to who you want to benefit and why and to what extent. So, the intestacy rules really do not cater for, certainly for wealthy families. So I would say, always make a will. It just makes sense.
Yeah, you can specify exactly what you want in it then. If the parents are residents in a foreign country and the children are residents in the UK and the parents hold assets in a foreign country and the UK, would the parent need multiple wills to cover all countries? Would the children in the UK have to pay inheritance tax on all assets, including foreign assets? It's two questions.
That's a complex one. I think you'd really need to work your way through that. What I would say in terms of foreign wealth, you need to look at the jurisdiction, first of all. So a number of the European jurisdictions, for example, they have automatic rules of succession, France and so on. But it's often the case that we would say to our clients, get advice from a lawyer in that jurisdiction to see what they suggest. We can, of course, only advise on English law. But also, yes, the questioner was asking about, parents are in one jurisdiction, children are in another. Yeah, that's a bit tricky, and you need to work through the issues there. It's not easy to provide a sort of a one-off answer there. I
Yeah.
think you need to think about that one.
Okay, on that one, definitely get advice.
Yeah.
Most of our investments are under EIS or SEIS. Will the benefits of these carry to those I leave them to, assuming held for 3 years?
Yes, so EIS, Enterprise Investment Scheme, and SEIS is Seed Enterprise Investment Scheme, I think. So these are investments which qualify for inheritance tax relief at 100%, I believe, after you've held them for 2 years.
Yep, 3 years.
3 years, is it? Yes, once you've held them for the requisite period of time, if you're still holding them at the date of your death, then they can pass to your non-exempt beneficiaries, your children, your grandchildren, free of tax.
That's great. That's a good one to know. Then this one, thank you. 2 follow-ups to my previous question. How would you document the intentions accordingly? So I'm assuming that would be in a will. And I had opened the joint account 5 years ago. Is my understanding correct that in 2 years' time, the funds in the joint account will not be taxable, given the 7-year rule?
So the first question about documenting your intention.
For the joint account.
Well, it doesn't have to be in a will. You can do a separate side letter. And there are a number of things that we would recommend going into a side letter. We talk about creating will trusts. If it is a discretionary trust, we always usually recommend a letter of wishes, which is a separate private document addressed to your trustees, executors, setting out the reason why you've made a will in that format, what your priorities are, and other things that you wouldn't necessarily want to put in a will, bearing in mind that the will becomes a public document once it's admitted to probate. The letter of wishes is private. It's addressed to your trustees. It's not disclosable.
Is that binding though?
It's not binding. It's not legally binding, but it's you expressing wishes. But if you wanted to make it clear, for example, I think the questioner was talking about the joint bank account and the intention behind that. Simple letter confirming what the agreement is between the two of them, signed and dated by both of them, would address that issue.
Great, nice and clear. Can't trusts help people not knowing what is in your will?
Yes, so if you were to do a fully discretionary will trust, effectively what you're doing is that you're passing the decision making on to your trustees rather than you deciding who's going to benefit. And then you've got that separate letter of wishes on the side that's private, which where the trustees will usually comply with those wishes. So it could be kept like a private arrangement in that way.
Can we have access to this webinar recording to review again? Yes, so webinars are recorded. They'll be on our website and on RIAA Barker Gillette's website as well. There is one more question, which is from me for a personal question. So should I make a will now with my fiance or after we get married?
Good question. So first of all, it's worth bearing in mind that marriage automatically revokes a will under the Wills Act. And so if you were to make a will today and you get married tomorrow, that will is revoked. But to prevent that happening, we can put a declaration at the top of your will to say that this will is made in contemplation of my forthcoming marriage. And on that basis, that rebuts that presumption and the will remain valid after the marriage.
Very interesting. I did not know marriages completely get rid of wills. That's good to know. I think that was all. Oh, no, there's 2 more questions. Sorry, I think these will be our final 2 questions. Is there a standard for a letter of wishes? Wills made 20 plus years ago and still valid, but the odd picture now would be better to an individual.
Again, good question. So we certainly have a template letter of wishes that we work on with our clients, and it contains a number of, I suppose, prompts, headings for them to think about. The good thing about the the will trust with the letter of wishes backing it up is that it's very flexible. So you can create your will trust on, today and your letter of wishes. But if in, say, 10 years' time, the family dynamics have changed, the beneficiaries you want to benefit under the trust have changed, you can update your letter of wishes and you don't need to go back. You don't necessarily need to sign a new will.
Yeah.
So it's a more flexible situation.
Great, thank you. And final question, can family members not in the will challenge it? For example, if I left everything to a sibling and not to my spouse?
Yes. The answer is that it's always possible to challenge a will. I mean, it obviously depends on the circumstances, but we do have testamentary freedom in this country to make whatever will you wish to make, but that is tempered by, we have something called the Inheritance Act 1975. It's a very long title. It's the Inheritance brackets Provision for Family Independence Act 1975. And if you come within a certain category of people, not everyone can do it, but certain category of people, spouses, ex-spouses, believe it or not, children, persons treated as children of the deceased, etc., they may be able to make a claim against the estate on the basis that, to quote the wording from the statute, the will or the intestacy does not make reasonable financial provision for them. That's not an easy case to make. And again, you really want to avoid litigation in the family because it's such a huge drain on family wealth. The only winners in that case are going to be the lawyers.
All right, thank you very much, James. How can attendees from today's webinar contact you if they've got any questions? Do you offer a consultation with people before you draft wills? I'm
always happy to have a chat with clients beforehand to see how we can help them. We usually send our standard will questionnaire to them so that they can provide us with a bit of information in advance, and we can see what's involved and we can develop the conversation from there.
Great, thank you very much. The contact details will be available after this webinar as well, or once the webinars have been posted on the websites, you also have contact details there. As we said earlier, in case some people just joined or weren't listening, this is a two-part webinar series. So the second one will be on the 15th of March and will cover lasting powers of attorney. It will also be with James, so he will be back. If you've got any questions ahead of time, feel free to email either Dragon Argent or James, and we can get back to you on them.
Great.
But thank you very much, James, for joining us. And thank you, everyone, for your great questions.
Thank you.
And have a wonderful day.